Legislators are here, and it's time that we embrace these topics. You have very hard work. I'm glad to be a part of it. I hope that you take on these topics and the other ones you've heard: fatality reviews, risk assessment, confidentiality, reporting. These are the other big topics of our work that need fixing, and now's the time. Thank you.
Doctor, why don't we start down at your end?
Thank you, Frank. That was great. I wanted to make a comment about the CPS versus GPS, and I know we've talked a little bit about this before. And I think part of the issue is that the GPS-CPS system, the way that we've set it up, implies that we know from the time of reporting whether something is GPS or CPS. And in fact, at the time, it's GPS is for non-abuse cases. I don't know if other people in our hospital, we cannot do a GPS report without parental permission because it's not considered to be a report of abuse because the law specifically says these are non-abuse cases. And this has completely changed the way that we think about GPS. But I think my feeling is that GPS versus CPS, it's a differential response. We have a differential report, and it implies that we know from the time of report whether something requires a GPS response or a CPS response. And I think that gives way too much, I don't want to say responsibility to the mandated reporter, who really should just report they know something. I said, what's your sense is the fundamental issue of GPS versus CPS in terms of what we would need to change? Does the whole system need to change, or is it just the part that you respond to? Or, what is your sense of what really has to change?
Well, first of all, I think that's a marvelous distinction. It's really smart, and it's neat that it comes, in a sense, from the ground up in practice. That the root of this, by my measure, is a civil liberties one. That the CPSL and the whole intrusion of Child Protective Service must be taken in the context of family privacy. The government doesn't get to be in your life as a family unless there's some cause related to abuse, something that compels us to act. And the need for services will probably be seen as not sufficiently compelling to force open your front door. So we have to reframe the conversation so that it takes account of family privacy and at the same time captures the knowledge that you acquired when you met that family or that child that a service is needed. Right? In point of fact, when you if you were to make a differential report to someone and said, well, I think this child needs services, even though I don't have cause to make an abuse report, by my measure, it doesn't rise to the level of abuse. It's what you're suggesting, right? You're sharing private medical information with people outside the circle entitled to receive that information. You are inviting the state into a family for which there may not be cause. So that's the threshold. It's a difficult threshold. That's where it comes from, and it's the one we have to pay attention to, because we all, in a sense, we all want it there, right? We all want some civil rights boundary, liberal, conservative, so on. Does that answer?
But I'm going to ask a follow-up. So most of the GPS reports that are made are around issues of neglect. And the consequences of that neglect can be much more severe than the consequences of physical abuse or sexual abuse. And in fact, in my experience, the disaster cases historically have been those where there's been maybe 3, maybe 5, maybe 12, maybe 20 unfounded and founded GPS reports. And so I don't want a situation necessarily where you need parental permission to make GPS referrals. And in fact, what I got from Rachel's comment was that there really should be no difference in what a mandated or any other reporter is reporting. That if there's going to be a difference, it should just simply be in the response of the system or the investigators. But that to have a situation where you need permission to voice a concern about a child or the child's safety, I don't think that's a good idea necessarily.
Yeah, so I think you got it right, but let's go back to where you just started. It's totally illustrative of it. That's our neglect system. If you ask somebody, what's GPS? They'd say that's where we put our neglect cases.
That's what they say,
right?
yeah.
That's what they say.
They do.
It's another of the ways we define Like I said,
Right.
we all make up our own definition. That's one of the recurrent ones. Why do we do it that way? Because we can't get it in the front door of CPS. That's what's wrong, right? Now, that's what you're flagging, that the CPS front door ought to have some way of taking account of neglect cases. Maybe the neglect definition is itself too high. We didn't explore the definition of severe physical neglect. You have to have prolonged or repeated impairment. It's a high standard. Jason will talk about that. So I want to say that GPS it shouldn't be the neglect system. It should be the voluntary services system.
I guess what I was saying was more that the person who's calling it in cannot assess that risk
Yeah, that's the other point you
at the
made.
time that they're seeing a child who's neglected. Because that child who's been neglected may well have had a sibling who died and 5 other things that CPS is aware of. And they all need to come in through the same report. And then CPS, who has far more knowledge, and potentially the police or other people, then can decide whether that's really a voluntary service or whether that family needs more than a voluntary service. So I think my concern with the system is that it's not, that it requires it's complicated for the reporter. Because I'll call CPS, they'll say, Childline won't take it, so call your own GPS. And you say, okay, I'll call my state, but how am I supposed to make that distinction now? So I think it's more the who's going in the front door and letting everyone in the front door, and then people who have more knowledge than the reporter decide what back door it goes out, who does it after that.
And if I can comment for a minute, I was trying to think this through as you were talking, Dr. Berger, and for the average person, they call a report in, and when the report is made, they don't need to distinguish between GPS, CPS, and they call it into Childline. Childline makes that distinction. The difference is for medical, because you've got these HIPAA laws and regulations, and that's why you're only allowed to share that medical information if you suspect abuse. So that's a little different. But if I, as an average person on the street, if I see a case where I feel a child is being maltreated in any way, I make the call. Childline then will take that, and then they distinguish and get that to the appropriate agency. And they either number it if it rises to the level of a suspected CPS, or they'll say this needs to be investigated as a GPS. Now, differential response is an issue that from the day I walked in the door, I believe we need to explore. And what does differential response really look like? And a lot of what you said, Frank, is exactly what we need to take a look at. So I appreciate you bringing that up for our attention, because I don't believe we have a differential response system. I like what you said. It is kind of like a differential report. Maybe not from your area, I'm thinking even from Childline to the county agencies, but we don't have a differential response that I can see. So unless somebody can tell me otherwise, I think you're absolutely right about that, and we do need to explore it.
Slightly different area of inquiry, Frank. You had mentioned in your outline that you would touch on the issue of types of cases of child abuse overturned on appeal, how the process influences current decision-making, the appellate review process being onerous and restrict and opaque to evaluation. And I'm wondering if you could just perhaps elaborate a little bit more on that, and also the issue of expungement and pardon as that enters into the process as well.
Expungement and?
Pardon,
Yeah.
gubernatorial pardon.
Yeah, sure. So what I meant with that in the introductory remark was so for example, I didn't mean to overstate it, to be honest, but so the way PR gets decided, the belt buckle case gets decided, it gets read as requiring intention. The world goes out to think that child abuse is only an intentional act. The legislature then makes some adjustment that kind of gets it that people don't internalize. And then a subsequent court, FR, says, well, PR got it right. This is the FR case. They got it right, and this is what it meant. And in fact, the standard remains a bit unclear and I think unworkable. That's really all I meant about it. I mean, certainly we know as lawyers and judges that the opinions are what they are. They're out there. I didn't mean to make any comment at all about, for instance, unpublished opinions or anything, that side of opaqueness, but only that we're sometimes not so good at applying judge-made law.
Okay, that answers it. Thank you.
Well done, Frank. We go back longer than you'll care to admit in public here. We've heard quite a bit of testimony and gotten a lot of...
Sometimes on the different sides of things.
Absolutely.
We should be clear.
Absolutely. Far more often than you care to admit, we're on the same side. A lot of discussion about the yin and yang, as it were, of GPS versus CPS, and bringing your institutional wisdom to this question. We deal essentially right now, we've been talking about the Juvenile Act and the CPSL. And are some of the things that have been addressed caused by the result of having two separate and distinct statutes? In other words, could we eliminate some of the problems we're discussing and things we experience by removing dependency from the Juvenile Act and combining it with the CPSL?
Nah. No, I think I know, in a sense, where one might go with that kind of restructure. There are, in the kind of, one might say, macro view of the structure of things, a couple of different scenarios. One would be to separate delinquent and dependent kids. So now you bring your dependent kids, in a sense, into the CPSL. The Child Protective Services Law mostly looks at injuries and, in a sense, at offenses. Looks as much to perpetrators as not, and it's not a service provision statute. It's a investigative and reporting statute. So you'd have to add to the CPSL all of the service provision mechanisms of the Juvenile Act. That would be a fairly large re-engineering. The other, some of us were talking about over lunch, is a kind of an old idea that we split out, and perhaps it was suggested by some of the earlier panels, that we split out the investigative and service delivery dimensions that there is in the history of child welfare, the development of child welfare systems in this country, some blending. They weren't always together. Of course, there was no child abuse right at the beginning of time. There was just chattel. And then we get to the point where we have abuse of kids and of women recognized for what they are. And then we develop systems that investigate those separately. There is a literature about the law enforcement investigative dimension being appropriately separated from the service dimension. It's another big retooling. I don't know that we have the wherewithal as a community, as a government, to do that level of retooling. In a sense, we may be too far down this road. It's an interesting theoretical question, but in the world of which several $billion you need and where you'd spend it, I'm not sure that it would be best spent there. But you would have to, one would have to explore that, cost it out, and so on.
Completely unrelated, and I don't know if you're familiar with this case. There's a case, I think it's another PR case later in the 2000s, deals with child abuse in the corporal punishment setting and raising the legal standard to a criminal negligence standard. Are you familiar with that case at all, and can you address that at all?
I think it was the, well, I mean, FR follows PR.
It does.
And uses the criminal negligence standard, applies it. I don't know if that's what they're thinking of.
And have
I mean,
you...
that whole line of cases is using child negligence, or what do you call it, criminal negligence as the operative,
Right.
right?
And can you weigh in on whether or not that standard should continue to be applied in that setting?
Yeah, I mean, I tried to be as clear as I could be that we ought to have something more clear and accessible, that foreseeability ought to be a piece. I'm not sure that the criminal courts are great at it, but certainly our courts are not very good at trying to understand what it means to have reckless disregard. I don't know that I can add to the remarks that I made earlier, that there ought to be an element of foreseeability, and there ought to be a more accessible layman's understanding of the consequences of your actions. That if I throw this bottle across the room, it's likely to, well, if I throw it, it's not likely to hit anything except the wall. But if somebody else throws it and if there has some chance of it hitting Mr. Heckler in the head, then I should be responsible for the consequences of what happens to his head. We're now at a place where it will be seen that I really didn't intend to throw that bottle, it just slipped out of my hands. You know, when we're using that kind of model for child abuse, we're in the wrong side of the equation.
Yeah. We're, okay, thank you, Doctor.
Thank you. Hi, Frank. You talked a lot about kind of what to do in cases where you have an undetermined perpetrator. And you made some recommendations for mandatory MDTs, tracking the children, providing services. Part of my thought process is, like, why do we even unfound cases just because a perpetrator cannot be determined? And can't we just say, or wouldn't this be a good solution, just to say, in cases where there's clearly child abuse, but we don't know who the perpetrator is, it's still child abuse? And then
Right.
you get tracking the children, maintaining record of the adults in the household, providing services to children without volunteers and stuff, without them volunteering, et cetera.
Yeah,
What are
so
your thoughts?
The standard definition of child abuse needs three parts. It needs an actor, a subject, and an act. Right? What you're doing is taking out the actor, and you're saying that the subject and an injury, perhaps an act, will be sufficient. And you will vastly expand the number, and well, I don't know if you vastly expand the number. You're not going to vastly expand the number because but you may have the unintended consequence if you take out. So if you don't study the actor, one implication of your suggestion is that all injuries that look like this get to be called child abuse, and we certainly don't mean that, right? So it was intentionally inflicted. Kid has a fight in the playground with another kid. If we're not asking about the actor, now we're left to the injury. We didn't mean that.
I'm not suggesting that we don't ask about the actor, because in many cases you can figure out who the perpetrator is. But, we talk a lot about cases where we have young children who have serious injuries and we don't know who perpetrated the.
Yeah, so an inflicted injury that meets certain definitions, right, where you kind of carve out or carve in a kind of restricted definitional sense, so that you get to call it child abuse. The next question becomes, why call that child abuse?
Because then it gets counted.
That's
and
right,
then
it gets
can-
counted.
and
That's
then-
where we want it.
And then
That's
you
exactly,
can't, you don't.
we want the answer to be that. We want the answer to be that. In fact, that's not the main reason we call things child abuse, so that they can be counted. We call them child abuse so that the perps can be held accountable and the children can be served.
Right.
So you just have to put all of the pieces together and understand what's left in the scenario you're describing. So in the scenario you're describing, if it is really that small subset of cases, perp undetermined, that for which there is demonstrable evidence of inflicted injury, and we believe that that child is either in need of services, right?
Correct.
And or that the department ought to track that for its various statistical purposes as we described, sure. But now we've developed it's a very narrow little window that you're talking about.
Okay.
Rather than the very slippery slope of, well, we take perp out of the equation.
Okay. Thank you.
All right.
That was
Further? Wow.
I'm going to give you an opportunity to respond to just that brief mention of the creation of an ombudsman. And I think we have a general idea of what that would be, but how would that creation of that position facilitate perhaps the prevention of child sexual abuse? Have you thought about it at that level too, not only responding to the general responses here, but how would it play in the prevention of Pennsylvania protecting our children?
Yeah. So I think it's important to recognize that classically ombudsmans, or as the one in Philadelphia, in Pennsylvania, the current proposed legislation uses the phrase the Office of the Child Advocate, have as their, in a sense, intended subject matter government problem. not perpetrator problem. So the inquiry is generally about what government may or may not have done wrong in the person of county administrators and agencies, probably class, and the second thing is they are typically do not account for the courts, both because of separation of powers issues and because no one really wants to get into questioning the decision of a judge outside the judicial proceeding, right? You'd have this extrajudicial review. Nobody wants to go there, right? So the courts get carved out. One of the subjects that's still in play is whether probation officers who work for the courts and their actions should be reviewable by an ombudsman, okay? So we're talking about government and government performance, government accountability. That's the main driver in ombuds functions, right? So the prevention aspect really is in a kind of longer term way, I think. At least at this juncture, what I think of is that, again, it's back to the fine motor skill that we started with. Government performs better, kids are better protected, right? Certainly among the organizations or services that might be subject to review might be the provision of prevention services, right? The current statute, Representative Petrie's bill, covers child welfare, and child care services. It's a kind of a large circle. And so you might imagine kind of malfeasance problems on the part of a provider as being reviewable. Right? But it is really about problems in the provision of service, unfairness, perhaps bias, certainly possibly abuse that went otherwise undetected. I think in that sense. Were you thinking of something else?
Well, now I want you to then to think, what do we need to create in addition to that? Or what do we need that can focus? You know, when I think child advocate, I think part of that is prevention, primary prevention piece. I think there's a role
Yes, we need to create a division of prevention services, a line item for prevention dollars. The Joint State Government Task Force on Children and Youth Services that I chaired and made its report in 2002 has a whole chapter. People were very, very committed to the notion that prevention should be findable in the budget. Today, you can't find it. And many of us know that we spend a lot of dollars on prevention, not enough, but a lot of dollars here and there. As you know, I chair the Children's Trust Fund. We let $1 million a year in prevention services. We could easily let 10 million or 100 million in terms of need, right? So those are where I don't think the ombudsman per se is a device to effectuate child abuse prevention, but it certainly should have that kind of salutary effect down the line.
If I may, you mentioned fatality review, and that's a concept that has been brought about. Do you or the people you assist or represent participate in the fatality reviews now that they're occurring?
So I, for many years, sat on the Bucks County team. As you know, I'm a Bucks County resident. If you sit on a fatality team, I think this is still the case, you have to sign a confidentiality agreement because of the larger confidentiality laws, which in this context seem to me a bit absurd. I believe that the right of a child to confidence went to his grave with him, sadly.
Yep.
And people shouldn't be allowed to hide behind the dead child's need for privacy. Right?
Yep.
Clearly, if there are remaining issues of privacy of survivors, we should process those. The near fatality cases have kids who are still with us, thankfully, and so there may be some other privacy issues there, right? But you have to sign a confidentiality agreement, and I never wanted my hands tied in that way. As an advocate, I felt it important that I and our office would be free to make comment, to press the system from outside. I do believe that the fatality review processes need a lot of work here. The Act 33 is a very good device that is really only being lived in the breach. It took a long time for counties to get going. There remains a very serious question about whether they're even responsible to produce their reports to the public with confidential information blacked out. We're not talking about that, right? Many counties believe that they're required by law to give it to DPW, which is then going to publish it. And then DPW publishes it in its annual child abuse report and online, and those reports, you might look at them, are sometimes detailed and sometimes downright scant. and almost in many of them, make no mention of whether children and youth was involved. The Philadelphia DHS model is a very good one. Philadelphia DHS, by my count, is the only county that will provide those reports to a public on request. I get them regularly because I ask. Kathy Palm and I have this kind of long shared task of getting county agencies to produce them. So we could show you a lot of documentation about all the different ways the counties are ducking the question. Lastly, perhaps most importantly, functionally, Act 33 lives in the section of the act that is titled Review of County Performance. It's an accountability device. It's a prevention and accountability device. All fatality reviews are look-backs. They ask, was this preventable? That's the rhetoric and that's the model. That's the raison d'etre, I should say, of a fatality review. Could we have prevented this? What can we learn from this child's death to do it differently? And yet, we're not asking those questions. Those findings are not getting presented, or at least from what we can tell, they're not apparent in the public document. So what are we really learning from them?
That would be,
But Frank, you would agree that if there is a potential of a criminal prosecution to occur, that those records should remain confidential with due deference to the prosecutor.
Yeah, so you remember there is in Act 33 the required sign off of the DA. That's not why they're being kept, I believe. The DAs, they hold them for a time, then they sign off. I believe the legislature took care of that in the drafting. We were involved, lots of us were involved in comment about that. I think the DA's Association was entirely satisfied with the outcome of that, was that the DA gets to hold it back, in a sense, put a lock on it until they're done.
yep.
That's not what's holding them up.
Yeah, well, that's what I think it at least creates the potential for everybody to decide that the system worked wonderfully, and the only slight flaw in the problem is that you got a dead kid.
Yeah.
So I'm yet to be convinced that there is any earthly use whatsoever, but that's
Any earthly
reason to believe that it's worth a damn.
to have a
And
study?
If it's going to be a holding people accountable, meaningful study, absolutely.
Oh, fine. Good.
Yeah, I'm
I didn't
not
think I was
saying
gonna have a fight
we
with you
should
on
look
that,
at it, but my limited experience has not led me to believe that they're worth a damn.
So, okay,
You got a dead kid and nobody stepping up, and that's.
nobody's stepping up.
But again, we've got another responsibility, and that we'll discharge.
Good, yeah.
Okay, thank you very much. I'm sorry, did you have a question for Mr. Sabrin? Okay,
wait, I want one more comment. I want to fight both of you on that issue, at least when it comes to Philadelphia County, because I do think that our Act 33 review team in Philadelphia County, really, the purpose of those meetings is to look at system-wide issues. And, there are some cases where the department has not been involved, and there are some cases where the department has been involved, and we recognize significant issues that we need to remedy. And we've come up with some important and helpful remedies. So I would invite you at some point, if we're allowed, to sit in on an Act 33 meeting in Philadelphia, because they are meaningful, I think, and I think they do what they're intended to do.
Well, not only that, you're tracking of the recommendations from them. In the Child
That's right.
Welfare Review Panel, as you recall, we found that the process was marvelous, the studies were outstanding, the recommendations were hard-hitting, and then they sat on a desk and on a shelf, and nobody followed them. And I believe they've cured that. So now they track what they do about the recommendation. That's full circle.
That's right.
That's what ought to be happening.
And just so you know, Frank, many counties are doing that, and we have regional people that go to every county. The problem has really been, are they asking the right questions?
Yeah.
And do we have standardized questions? There's been a work group meeting to come up with what that should look like. The other problem was, and it's a manpower issue. It has just never been put up on the web the way it's supposed to be and the way it was supposed to be. We will be remedying that, but I don't want people to think that we're not doing our due diligence and looking at each death within that time frame allotted by law. We send regional people in to have those meetings. And I sat through a bunch of them in New York. They're brutal. They're the right thing, brutal honesty, recognizing the issues. We had some of our doctors who cried, we all cried. It was, truly, I think it is doing what it was supposed to do. We just haven't documented so others can see it, unfortunately, the way we need to.
Mr. Savron, thank you very much.
Thank you, sir. Thank you.
And for the work you do. And next, Ms. Ginsburg, I apologize that we're being tardy, but we will remain here until the sun goes down.
Right.
At least I will.
I have a plane to catch.
speak
but-
for-
on a train.
Yeah.
That's okay.
Floor is yours.
Okay. I want to thank the Task Force on Child Protection for inviting me here to speak today. My name is Janet Ginsburg, and I'm a senior staff attorney at Community Legal Services. For those of you who don't know, CLS is a nonprofit organization that provides free legal assistance to low-income individuals in Philadelphia. We have units that do landlord-tenant, utilities, public benefits, mortgage foreclosure, and employment. While the employment unit handles a lot of more traditional employment law, the largest need for our clients right now is addressing barriers to employment, such as criminal records and child abuse records. Our family advocacy unit, which collaborated with me on this testimony, is a special unit within CLS which provides representation to hundreds of parents each year in Philadelphia dependency proceedings. My office has represented hundreds of parents, siblings, family members, and caretakers who have been placed on the Child Abuse and Neglect Registry and seek to appeal their indicated reports. The previous speakers have spoken very eloquently about the tragic cases in which real abuse does not get properly reported, properly investigated, and properly followed up on. I'm here to speak to you about the opposite, the many cases in which well-intentioned but overzealous advocacy leads to erroneous findings of child abuse with significant consequences to families. Our experience with and perspective on child abuse reports, I think it's fair to say, is vastly different from that of the previous speakers. But I think we all ultimately share a common principle, which is that the children of Pennsylvania are best served and protected when the system gets it right. CLS, as I mentioned, regularly represents and advises individuals who have indicated reports of child abuse that are affecting their ability to find and retain employment. A caretaker, as you all know, what it takes to get an indicated report is a caretaker checks a box, a supervisor looks it over, and it gets sent into the child abuse registry, and the person is on the registry. While the statutory goal of protecting vulnerable children is of course necessary, the consequences of indicated reports to workers and their families can be extreme. People with indicated reports are barred from working in daycare, education, healthcare, nursing homes, paratransit, and a growing number of other jobs, predominantly ones filled by low-income workers. Many of the indicated reports that we see are based on faulty or incomplete investigations or on actions or omissions by our clients that simply do not meet the statutory definition of child abuse. The inability of parents to find work due to an indicated report can have significant consequences for their children, and I urge caution in opening the door to indicating more reports without ensuring that reports of abuse are properly being substantiated. We recognize and applaud the extremely important interests that Child Protective Services agencies serve in their ongoing efforts to protect children from abuse and neglect. At the same time, we believe that some social workers and supervisors, perhaps in an excess of caution, indicate reports too casually and do not comprehend the significant financial and emotional toll on the family that can ensue from an indicated report. In litigating these cases, it has become very clear that many caseworkers don't actually understand the definition of child abuse. We will ask them on the stand, what is the definition, and many of them don't know it. Sometimes they are just not conducting adequate investigations, either by following up with medical professionals or with witnesses. We also see many instances in which false accusations of abuse are raised in the course of contentious custody disputes. Investigating social workers often acknowledge this as a concern, even question the subject child's credibility, and indicate the report anyway. We are concerned that the indication of reports can also be attributed, in part, to economic, class, education, and language barriers faced by many of our clients. Moreover, unless and until an individual named as perpetrator appeals the indicated report of child abuse, there is no impartial forum or adjudicatory proceeding in which our clients can be said to have had an opportunity to present evidence or an explanation and present their rights. The consequences of wrongly indicated reports are exacerbated by the extremely short time frame within which people are permitted to challenge the reports. As most of you are aware, an individual must appeal an indicated report within 45 days, or they are on the registry for life. Our clients, who are generally not well educated or sophisticated, often do not receive the notification, do not understand it, or do not recognize its significance when they do receive it, and thereby miss the strict appeal deadline. I like to think that our lawyering is good enough that we're sometimes able to get beyond that deadline if they have missed it, but in many cases, there's just nothing we can do, even in cases that clearly on their face should not have been indicated in the first place.
Well, if I could, just on that point, I can't imagine that courts haven't carved out some kind of an equitable remedy where there actually hasn't been notice.
It's very hard to prove lack of notice, as long as, we definitely make that argument where there's no notice, but under the mailbox rule in Pennsylvania, as long as DPW can testify, as they always do, that they mailed the letter, that's considered sufficient. Lack of receipt is not sufficient.
It's not like a PennDOT license suspension situation.
That's right. So unfortunately, when our clients sometimes live in public housing where the mailboxes, basically the mail's all put in a big pile, but that is not considered sufficient by the courts to lift the deadline. We've been able to lift the deadline in cases where we can prove that the address is incorrect or the client didn't speak the language that the report came in, which is English.
Well,
Spanish is now on the other
if
side.
one of the things that then might be helpful would be if you folks want to get together some kind of a suggested alternative.
We would be very happy to do that. I've actually been in discussions with DPW for many, many years over trying to find alternatives. I'd be happy to talk further with anybody about it. Okay. So under a subfile created by current law, names of perpetrators are kept and released with child abuse clearance forms for life. Consequently, a lifetime barrier to certain types of employment is created, as I mentioned, in an ever-increasing range of jobs. Finally, the wait for a hearing and a decision for those who do appeal timely, the wait has become incredibly long. It's not unusual for the process to take well over a year, sometimes even a year and a half. Concern has been raised today that reports of child abuse are under-indicated. I hesitate to say that they are over-indicated, but rather that what we see in our practice are a large number of reports that are wrongly indicated for actions or omissions, as I mentioned, that don't even begin to meet the statutory definition. The following is a small sample of wrongly indicated reports that we have indicated over the years. A mother indicated because her son forgot to bring his asthma inhaler to school, following, by the way, a night with the non-custodial father. An 18-year-old sister indicated for child abuse after hitting her 16-year-old sister during argument over a borrowed sweater. Parents indicated after a caretaker fed egg to a 9-month-old baby unknown to have any allergies, which caused a minor rash on the arm. Parents or caretakers indicated for accidents or unexplained injuries that occur in the regular course of children's lives, often while the child is at daycare or in the care of the other parent. Parents indicated after the lawful use of corporal punishment. Parents indicated for medical neglect because they felt in their best judgment that an accidental burn or hurt arm or diaper rash could be treated at home and watched before realizing it was worsening or becoming more serious than they had thought. Daycare workers indicated because one child bit or otherwise injured another child. It's important for me to stress that these cases are not outliers, but examples of the sorts of clients we see every day. In the 13 years since I started working at CLS, our office has represented or advised approximately 500 clients with child abuse appeals, and we have encountered countless incidences of people who've been placed on the registry and become unable to support their children because of situations that could, and I would argue do, happen to just about every parent. Certainly, the people seeking our assistance are a self-selecting group. They are not the parents who burn their kids with cigarette butts or are committing regular serious child abuse. They're the ones who are outraged to find themselves on the child abuse registry because of a single error or an understandable but consequential lapse in judgment, or an act committed by another person that they could not have foreseen or prevented, or the imposition of corporal punishment that they believed was necessary and lawful. Parents who get put on the child abuse registry for corporal punishment certainly present some of the murkiest and more difficult issues. We see many instances in which a parent spanked a child without resulting in serious injury, and the investigating social worker filed an indicated report merely because, we see this all the time, parents should learn methods of punishment other than corporal punishment. Often we see the words severe pain put on the report in different handwriting, which indicates to us, and we, during the investigation, can get out in testimony that the social worker didn't really see severe pain, but the supervisor insisted that those words be put in so that it could be put on the child abuse registry. I do understand the concern that has been raised with the requirement of severe pain before the indication of a child abuse report. It is a subjective and imperfect standard. However, whether one supports or opposes the use of corporal punishment, it is legal currently in this Commonwealth. And it is a concern to us that eliminating the use of a severe pain standard would likely result in reports being over-indicated. Without that standard, there will be many cases, in many cases there will be no way to distinguish between lawful corporal punishment and true abuse. I would like briefly to follow up on the suggestion that bruises alone should be enough to indicate a report of child abuse. We do not believe that bruises alone could be sufficient. I can tell you, as someone who walks into my living room table all the time, that I often have bruises on me that, were nothing more than an ouch. And, some people bruise easily, and I do think there needs to be some more of an objective standard, given that there are some children who can't express the pain. We do often see the scales that Frank Cervone used, the 1 through 10 scale or the smiley face scales, being used to help children articulate how bad pain was. But I do think that eliminating severe pain would, just lead to so many cases being put on the child abuse registry that probably shouldn't be there. I would, excuse me. In part because of the many instances we see of people erroneously being put on the child abuse registry, the child abuse registry as a screen for employment is problematic. Sometimes I would argue even irrational. Child welfare professionals involved in the registry's creation decades ago have told me that it was never intended to be used as an employment screen, rather to identify and address repeat abusers, repeat abuse by parents. And no studies support a correlation between isolated instances of even severe corporal punishment and subsequent mistreatment of children or other vulnerable individuals in an employment setting. The extremes are obvious. I have children in schools. I'm not suggesting that child sex molesters should be teaching in classrooms or working in daycares. However, I'm also not really concerned that someone who once foolishly left out a curling iron, or who didn't treat a burn quickly enough, or quite frankly, even someone who lost it once and smacked a delinquent teenage child, I'm not overly concerned about that person driving my child's school bus or serving my child's lunch, or even working in a daycare. I think that there needs to be much more of a correlation between whether someone is really not a safe person to have in a workplace environment before we ban people for life for many of the instances of child abuse that are currently on the registry. Also problematic in this regard is the fact that the registry itself does not distinguish between kinds or levels of abuse. Parents are regularly put on the registry as what's called perpetrators by omission, or failure to protect, after the other parent or a paramour injures or abuses one of her children, or one of the siblings does something to another sibling. In many cases, the parent did not know or have reason to know that the injured child was at risk. Thus, these parents are barred for life from a broad range of jobs, not for abusing his or her child, but because someone else did, and she's deemed to have not done anything to prevent it. Others are put on the registry for what's called failure to supervise, which is regularly applied in circumstances that I would assert happen to many, if not all, parents. Accidents that occur while the caretaker has stepped out of the room, has perhaps inadvisedly allowed the child to play with a toy meant for an older child, not placed sufficient guards on stairways. I stress, as other speakers before me have stressed, that there are services that can be offered to families, parents, training, that sort of thing, short of being placed on the child abuse registry and cut off from their livelihoods. I would like to address some of the specific issues that have been raised today and in the past by child advocates. First, CLS recognizes the frustration felt by many when a particular perpetrator cannot be identified, and in some cases a report of child abuse goes unfounded. We often see the opposite. In an effort to ensure that someone, and hopefully the correct person, is being indicated, a number of people involved with the child get placed on the child abuse registry, often with little evidence that they were in fact responsible. Some call for a broadening of the definition from person responsible to persons responsible, thinking that will most likely capture the one individual really responsible. I suggest that this approach has serious due process concerns. I think and hope that we would all recognize this approach as problematic in a criminal case, where the prosecution must prove beyond a reasonable doubt that the defendant actually committed the crime and wasn't just included in a group of people who may or may not have done it. Being placed on the child abuse registry, as I had discussed, has quasi-criminal ramifications, despite the lower burden of proof, and with a great deal less due process afforded. CLS urges caution in redefining perpetrator in a way that would seriously compromise due process even more. Again, there are ways for these children not to get lost in the system and for them to get services even if somebody is not put on the child abuse registry. Similarly, we would caution against expanding the definition of perpetrator too broadly. The criminal justice system already provides mechanisms for penalizing individuals who abuse children, and there are quite a number of laws in Pennsylvania and nationwide for preventing them from working with children. As I have stated, the process of placing people on the child abuse registry is rife with error and lack of due process, and many more safeguards must be put into place before expanding the definition of who can be put on it, particularly since many of the newer additions proposed would not be able to be provided with some of the alternative services available to families. CLS also believes that the definition of non-accidental should not be expanded. It is our position that the standard set by the PR case is a reasonable and cogent one, and I don't say that just because our office represented PR. Critics of this standard feel that any act of corporal punishment is intentional, and therefore any injury that arises from it, even if the injury itself was not intended, must necessarily equate to child abuse. The PR court and the legislature that subsequently wrote this standard into the law correctly felt, we believe, that the second part of the definition, disregard of a substantial and an unjustifiable risk, and the standard of criminal negligence, adequately holds parents accountable for their actions and still recognizes that parents using lawful corporal punishment should not be held strictly liable. The CPSL, as it stands now, is comprehensive. Rather than broadening the definitions of child abuse and adding more layers to an already complicated law, CLS strongly believes that children and families would be better served by better training, identification, and investigation of child abuse as already defined, and also more effective follow-up. It is important to emphasize that, as has been emphasized here already, that there are ways to protect children that do not require a finding of abuse and placement on the child abuse registries. Families involved in so many of the cases we see would be well served to be offered family services and parenting classes. Where appropriate, and following an evidentiary hearing that provides some more due process than is afforded in the child abuse registry, children can be adjudicated dependent, removed from the home without a finding of abuse. Because the stakes are so high for parents and caregivers, and their opportunities to defend themselves against child abuse are so narrow, we urge the task force to carefully consider the due process interests of the alleged perpetrators when reviewing and expanding the proposed regulations. In encouraging more complete reporting of child abuse under the CPSL and thereby protecting children from further abuse, there should be no rush to judgment as to whether or not abuse has occurred. The proposed changes must and should facilitate reporting and investigation while providing for the protection of the rights of those who have been alleged to have committed abuse or neglect. Thank you.
Thank you. I should know this, but part of this job is admitting my ignorance at any rate. If feel that I have been unjustly accused, I give notice with, let's say it's a timely notice of
Right.
appeal of that designation. My case is initially heard by a hearing officer of some sort?
Well, it's actually much more complicated and confusing than that, and which snares a lot of our clients. You would get an indicated report of child abuse. You have 45 days to write and say, I shouldn't be on the child abuse registry.
Okay.
Okay? They then send a letter back saying, we've received your letter. If you have anything else to tell us, write to us within 30 days. If you want to go straight to a hearing, write to us within 10 days. Okay? Time passes. Sometimes our clients write in, sometimes they don't. Time passes, and often many, many, many months later, often 10 months later, they've closed that a bit, but it used to be, it could be almost a year later, another letter follows up that says, we've reviewed your request. Sorry, we agree with the original finding. You have 45 days to ask for a hearing. That 45 days is also a statutory deadline. So our clients have two opportunities to miss deadlines. Once they've received that second letter saying, nope, we agree with them, you're staying on, they then say, I want a hearing. Then many months pass, assuming they get that in within the 45 days, and a hearing is eventually scheduled before the Bureau of Hearings and Appeals.
Okay. And the appeal from their determination is to the Commonwealth Court?
Once the Bureau of Hearings and Appeals has issued a decision, there's two routes to go to. They can ask for a reconsideration within 15 days, or they can appeal to the Commonwealth Court within 30 days.
Okay.
Right.
Do you folks, I guess it's hard for you to get into a proactive posture. I don't know whether the department, hope springs eternal, with the articulateness that you folks would have as counsel, you get these horribles that you've described to us, which I agree in many cases sound unjust to me. If you could make that pitch to somebody, whoever, whatever bureaucrat, no harm, is intended to get these things.
We haven't had those conversations yet, but we can.
Do you have any track record with that helping, or you don't hear from until people are way down the line?
We have tried, quite frankly, for the 13 years I've been at CLS to work with DPW. Part of the problem is, and with DHS as well, part of the problem is that the DPW is not responsible for the training and the investigation that's going on at DHS. We've tried for many years to make what changes can be made with DPW.
Oh, okay. Listen, I'm not,
I'm happy to keep talking. That's right, and I'm
sort of
always happy
setting
to keep
up a,
talking about it.
Gee, they're not unreasonable.
No, I'm not saying
I'm
they're
just wondering whether that's a technique that.
We have to do.
We've tried legislative advocacy, we've tried administrative advocacy. We are,
I believe so.
we have considered lawsuits challenging various aspects of the law.
But you see, I'm kind of a practical guy, and I was a trial judge. You give me particular facts and you can support them, you got me. Absolutely, this isn't what, and probably you'd have the most dedicated child advocate, sitting in DPW. On the other hand, so that you don't want to throw the baby out with the bathwater, we do want to list people who abuse kids in some way that's accessible. But injustices, I'm ready to believe injustices happen. I'm just trying to figure out how we make the system work so that there is a fair hearing somewhere along the line.
Well, first off, I'd like to thank you because you had the tough job of the day. To get up here before this group, and I believe everybody in the room, including you, is a child advocate. And that's not the issue. I appreciate that you presented the other perspective, because it is important that we always keep in mind that there is a balance. I've always believed you err on the side of the child, because you want that child to be safe. There's no question. However, I had the opportunity to spend my last 3 years before coming to this job in York County. And in reviewing many, many cases, hundreds of cases, I saw what you saw. And so it is true, it is accurate, and part of the problem stems back to the fact that we have a workforce that are made up of young, fresh out of college with no work or life experiences, who don't know what questions to ask, and who are making life and death decisions when they don't have an investigative background or even understand a lot about human nature, because they're all in their 20s. That's why my fear, I do have a fear of opening it up any further. Philadelphia may talk about Philadelphia and how it could work here, but I've been all over the state in the last 5 months, and I've got some serious fears that it can work everywhere. So presenting that balancing is critical, and as we move forward, we have got to remember that. So I thank you for that. I also agree with you that many people that we work with do not understand the letters that we send them. I saw that in York. I saw parents' rights terminated because one mom, she lived in a trailer. I mean, she was seeing her children weekly. I can go on and on with example after example. Also biases. You know, young kids' biases towards somebody that may have done drug or alcohol. We've got a lot of issues. The system has a lot of issues, and workforce is the very start of it. So I would welcome sitting down with you. I don't know what we can and can't do, but I certainly believe that we have to ensure that balance exists. I can tell you, as you said, once they're on the list, once they're on that registry, that's it, employment-wise as well as for other reasons. So that does make a huge difference in people's lives. But the worst is when, for the same things you talked about, not that they're on a list somewhere, but that we take their children and never return them. Right. And I've seen that too. So again, thank you. I know your job was tough today, and I appreciate that you did a very good job with it.
Well, now it's about to get tough, right?
No, honestly not. Janet, thank you very much, and Kathy, thank you also for being here. My dear late friend Alan Lerner taught me many years ago that, you know, to have a designation of being a perpetrator of child abuse puts you on a registry for life. And there are some people that we would want on a registry for life. There are some perpetrators of abuse who we don't want anywhere near anybody's child, your child, my child, anybody's child. But there are many parents who, even if they have lost it and hurt their child, it doesn't necessarily mean that they can't work in certain systems for the rest of their lives. I mean, I just don't believe that. And so I'm wondering whether or not there could be some system, because we do want to track families. We want to track people who hurt children, because they may lose their, get all frustrated and, lose control again, and that would mean a different thing potentially. But it almost seems like there is this immediate coupling of being recognized as abusing your child and going on a registry that prevents you from all kinds of employment for the rest of your life. I'll let you chair. I know you have a difference of opinion. I'm hearing it in my left ear. But why does there have to be an immediate and permanent coupling? Why can't there be some kind of a stepped response, or some kind of a system where certain people would go on the, never go near a child again, and then there might be probation, and there might be nothing, and there might be certain something or other. That's kind of one of my thoughts, and I don't know if we have the ability to look at those issues.
We would definitely support some kind of stepped system. I will also say that it did not used to be a lifetime ban. That was the result of amendments in 1995. It used to be that people could appeal child abuse reports at any time. Child advocates felt that records got old and stale, and it was too hard for them to defend. So it went from the extreme of having forever to appeal to having 45 days to appeal.
It also seems like the system is ridiculous. Like, it seems like whoever invented the system was on drugs that day. I mean, it just doesn't seem like a process that has...
Well, and if I can, for both of us,
And
own
if
up
you
to
made it,
this.
Bev, I apologize.
The two
If
of
you
us
wrote it.
were in the General Assembly We have to
Now,
admit it.
now I'm definitely going to be calling you.
Yeah, we were both in the General Assembly, and sitting in a room with 203, and then there's another room of 50, and you start saying, oh, child abuse, what you think is the worst, and not all the things we know are in between. There's one, there's this range of things, but that's not what you think when you're sitting in that seat. And when they say, my God, do you ever want this person to ever be around children? And if you don't push that green button,
Right.
yeah. So is that the realities? It is. It's more of an education process. It's an understanding of what child abuse really means, which we're trying to figure out ourselves, and how the system works, and even a recognition of what the whole piece of it. But we both understand that's how laws are made. You look at one issue, we just did that for, oh my God, we did something a year ago that was done for custody. You saw that? We changed custody, we had it changed again, okay. But that said, if you had a 20-year-old DUI and moved into your family's home and there was a custody dispute, you had to get an drug and alcohol evaluation. That doesn't make any sense. So a lot of times things happen that don't make sense, then we need to look at better ways to fix the problem, so.
I can't tell you how happy I am that you've presented today, because what you've had to say has been very critical. I think all of us that have made careers in this area probably have 2 or 3, maybe a half dozen cases that we'll never forget. And one of the cases that I've had that I'll never forget, actually I didn't have it but learned about, involved a situation where a woman, a refugee from Kinshasa in the Republic of the Congo, French-speaking, came to this country, and it was in the Refugee Resource Center in Berks County, got out, got her kids that she had fled with her, and went to work. One day, her babysitter was sick, and her backup babysitter was sick. Knock at the door, her kids are home alone. And all of a sudden, she's involved in the system. She has found not only in the civil system to have failed to supervise, but also in the criminal system is charged with endangering the welfare of children. And had some bad legal advice. She's on the list. Not only can she not get a job, but she can't get an education, because when she goes for an opportunity to get a loan, they're saying no, because you're on this list. And that's not the issue so much at this point as we then say, okay, you can appeal, but you got to do it within the time frame, and she didn't really understand English. Or in the criminal system, you can seek a gubernatorial pardon. Well, we set up these processes whereby we can correct the screw-ups that have occurred, but they're meaningless because they take forever and they just don't work.
I can tell you, though, as someone who spends my life correcting people's screw-ups, that they're actually not meaningless. When they work and they're available to people, they're not meaningless. They can make an enormous difference. And I think your point about the governor's pardon is key, because one of the differences between the criminal justice system and the child abuse registry, aside from the fact that there was an evidentiary hearing and due process in the criminal justice system, which is not there with child abuse, is that you can seek to get a pardon at any time. You have that available. You can even, if you've got an arrest, I like to analogize indicated reports to arrests. Let's say there was probable cause, but there's never been a finding of fact, right? You can get criminal records expunged if it was just an arrest at any time in your life. So 20 years down the line, this arrest is affecting your ability to get a job, and I can tell you it does. You can go get it expunged. You don't have that option available with child abuse records.
Right.
I feel compelled to address a couple things. One is I don't think the system's horrible. The child abuse appellate process is not horrible. Are there problems? Sure. I'm just. I think the word horrible is thrown out there, and I'm going to take issue with that. But more importantly, the misinformation or erroneous information that we've received. We need to make sure we understand the differences between indicated abuse findings and founded determinations. Indicated abuse findings are ones that the CYS or Child Welfare Agency makes administratively. There is no direct implication on employment. There's no bar to employment if you have, let me finish, an indicated finding of abuse. The only bar to employment, statutory bar to employment, is if it's founded. Founded occurs in one of 3 or 4 ways. A criminal conviction, either by way of guilty plea or verdict, a juvenile court judge's determination of the abuse, or a PF, protection from abuse determination, where the child is a protected person and is a final order. Those are judicial determinations, and the status of the indicated finding changes from indicated to founded. That is the only time there's a bar to employment. It's a 5-year look back based upon a Commonwealth Court decision. So when we talk about lifetime barring of employment, that is absolutely not correct.
If I can address that. It is true that the only statutory bar is for founded reports within the last 5 years. However, anybody who works in a school or in childcare must do a child abuse clearance. And first of all, I can assure you that no school or daycare is hiring anybody with an indicated report at any time in his or her life. Also, while it's not statutory, DPW does have policies, licensing policies, in which they will not license daycare centers that employ people with indicated reports, not just founded. So while the only statutory bar is for the founded reports, it is a lifetime barrier to employment for people who have the criminal records. They cannot find jobs. All nursing homes are doing child abuse clearances now. All paratransit is doing child abuse clearances now. I know someone who applied for a job as a Ukrainian translator who had to do a child abuse clearance and didn't get the job because of one. So the only statutory bar does not mean it's not a lifetime bar from employment.
And you addressed the 45-day appeal issue. Am I correct to hear you say that you are advocating to eliminate the initial administrative review so that your clients don't have the opportunity to miss 2 deadlines?
We've certainly always advocated there not being 2 different deadlines, but we don't think there should be we think the 45-day deadline should be repealed.
And remove the administrative process too, or?
No, you can still have the administrative process, but somebody can file an appeal at any time for that administrative process.
Do you have a suggestion on time frame that would be appropriate?
I don't have a suggestion. In the past, we've thought maybe 10 years would be appropriate.
Being a child advocate, you understand how that impacts the child's, I mean, I would suspect if you went to the hearing, the child's not able to be found or not able to recall testimony, you'd probably object to hearsay testimony at that point.
So my controversial response to that, which gets me into trouble a lot when I say it to child advocates, is after a certain point in time, why shouldn't people come off the child abuse registry? If somebody has not reoffended or hurt a child or left out another curling iron in 15 years, why shouldn't that person eventually come off the child abuse registry?
I'm going to be controversial and absolutely agree with you. I think one of my most difficult things in this state is recognizing that I don't want to call a spade a spade. I don't want to call a case abuse because I know what's going to happen to that family if I do that. And that should never be a position. I should not have to say that this is not abuse because forever this parent who did, as you said, one thing wrong will never be able to work with children. And I think I like Cindy's idea. There are certain people that should never take care of children. And actually a lot of the people are now Megan's Law offenders. And so they're protected through Megan's Law, not under the state. But a lifelong, I mean, we've seen people do dumb things when they're 18 years old, but to say forever, and if you look at most states, actually one of the things I looked at this morning as I was coming around the plane, all the other states, most of them are 5 years. And I think 5 years is reasonable. And if nothing ever happens in 5 years, then you take the person off. I was just involved in an expungement that was 9 years old. I don't know how it took 9 years, but it was a failure to thrive from 9 years ago. And I said, take the person off the registry. I don't care. It's been 9 years. This kid was 13 at this point and in the court. And they found it because at the time I filed it, it was a correct filing. And so they upheld the failure to thrive. And I thought, this is just ridiculous. And I think it creates a system where you've got all these people who are rightfully trying to expunge. So I would suggest that it's not lifetime. You set a time limit, 5 years. And then you also gradate. PERP by omission is different than PERP. And so I just think we have to have a little more gradation there.
Mr. Chair,
Hold on, Mr. IPOC has been quietly trying to be recognized for a while now, I think.
I can pick up the phone call and ruin your life for the next 2 or 3 years, and there's no,
Yes, you could.
there's no recourse. Thank you. It's a very good report, and many of the issues that I'm very sensitive to, due process. Absolutely essential. I explained the process that you began to explain as far as the review of an appeal or an appeal process to attorneys, to legislators, and they said, no, that can't happen in the United States. You can't wait a year, perhaps, when we appeal an indicated report, then have it postponed numerous times, then have your first day of testimony, and after that's concluded, wait 4 months for your second day of testimony, because we want a due process I want it for several reasons. One is, one way to protect children in the state is to have good people working with them and to have the bad people not working with them. Let's find out who they are. With the good data, good investigation, as you said, I've experienced all the things that you put out here in terms of we have some good investigators and we have some not so good investigators. And there has to be some consistency there. But given the fact that there may be bad investigation and life is in their families and their children are subjected to things that they shouldn't be, there should be a process set up, and there is legislation, I'd like to talk to you about it, that allows that process to happen as quickly as possible. And let's find out the facts. Let's put them on the table and move forward. But I appreciate your report very much.
Thank you.
And if I could, horrible is the kind of word I use sometimes, so I'm going to assume that I did say horrible somewhere in there. Let the record reflect, it certainly should have been assume arguendo that the process is horrible or whatever to get to whatever point I was making. We're here to gather information as opposed to reach conclusions just yet. I'll start pontificating when we've had a little bit more evidence. Mr.
To that end, the discussion about whether or not somebody continues to offend after the initial indicated, perhaps we could have our researching staff obtain evidence and information about how often people are commit abuse and how often they're actually caught and apprehended. Because there's a difference between whether or not you're an actor and whether or not you're caught doing something. And if we're going to go down the road of whether or not we should remove them or not, we need to know that type of data.
Well, and again, that's certainly a suggestion we can make. Listen, you're taking the prosecutor's line. Everybody's guilty of something, even if they're not exactly guilty of what we're charging them with presently. So it's not hard to get into that mindset, and sadly, it's not all that often wrong. What I'm hearing here, and what I would, and plainly you've got some other people with whom this is resonating, and I think to some extent this is going to be the 18 blind men or however many there are in a room with an elephant. Sure, a lot of what I'm hearing is parents that are presenting, for instance, to physicians. They're there, they plainly care about their kid. They did something dumb or something, possibly ignorant or something that they ought not to have done, but they continue to care for their kid. That's one whole subset, which is vastly different from the guy who is sexually abusing stalks some woman, winkles his way into her affections because she's got a 9-year-old daughter that he has his eye on. And that's one where, Mr. Koulakis and I are going to link elbows and that's it. Right. When somebody does that once, they're going to do it again and again for the rest of their lives. Of course, I would just prefer to see them in the bottom of some solitary confinement for the rest of their lives. But if they're going to be out anywhere else, then they ought to be on a registry the rest of their lives. But there are lots of different. This has been painted with a broad brush. I'm going to have to look back because I can't believe we did that in the Senate committee. So it must have been you guys in the House.
It was.
But that's the beauty of what we're supposed to be doing here. Is nobody gets to say to us just yet. I mean, the governor or everybody else may tear their hair eventually about, oh, this is a ton of resources, but we get to look at what we think is the optimum for protecting kids, including looking after their families when they have intact or at any rate somebody who cares about them and would like to go out and support them. So we hear you and would welcome additional dialogue. Are there additional questions?
I just have one other comment, and, you know, it seems to me, Janet, in listening to all of your anecdotes, and I have heard all those anecdotes, and I see cases where people, you know, determine that there was lack of supervision. They love to indicate things because of lack of supervision, and sometimes I say that's ridiculous. It's a ridiculous response. But, you know, you just wish there was a way earlier in the process where you could have really good, like, review of, you know, of almost every case, so that you just have like people looking and checking and making sure, because that you know, to the best of our ability, this truly is a child who, you know, as we were saying this morning, is in need of protection. And you know who is a child abuser, and you know, who do we have to protect children from? I just think, I wish we could do the better work earlier, so you get less cases.
I agree.
And you can sit on your stoop more.
Thank you. I'll see you there.
Well, let me just, out of curiosity, I assume that the DPW notice that says you're in child line doesn't say, and if you live in Philadelphia, call you folks.
Because of us, it does have some line about seeking legal services.
Well, how swamped do you think you'd be if that's one of the things that happened? I mean, I'm used to dealing in a criminal world where, you know, Miranda, the first thing we're doing is saying, hey, get a lawyer.
We would be very happy if people knew to come seek legal services. Quite frankly, I'm less worried in Philadelphia, where there are 5 of us working on these cases, than in the other counties where very, very few people are doing child abuse expungement work. So, you know, whether or not we're swamped, that's what we're there for. We would try to help as many people as we could.
Thank you.
Okay?
Anybody else? Thank you very much.
I think she.
Oh, I'm sorry.
On the other side of it, people who do go to the appeals, how many do win?
I've lost one in 13 years, and it's one I should have lost. I think the overturn rate, I think of people, I may be pulling this out of thin air, but it's close, of cases that actually get to a hearing, something like 90%, 92% get overturned. And quite frankly, and the child advocates would say that that's because a lot of the cases are stale and old. But a lot of it is also because they were incorrectly indicated, they didn't meet the definition of child abuse, or the investigation didn't present evidence to prove that they had.
They come in with their private lawyers. Some of I've sit in, and they're coming with their private lawyers. It's clearly a case that I sit on. I'm clear he did it. He busts the child's eardrums. The child has the injury. He comes in with this lawyer, I mean, a high-powered lawyer, and he wins the case. How could it not be abuse? I just could, but I know that they, most of the time, they win their case. So that's, I was just saying, look at the flip side of it as well.
And Mr. Chair, I know we're seeing it in Philadelphia, but there are many counties where that's not the case. Coming from Dauphin County, nearly 11 years, I tried about 850 of these cases before DPW and lost 2 from the agency perspective. So there's dynamics across the state we have to be cognizant of. And maybe we need to focus in on why are those dramatic differences.
And there are.
And with Philadelphia being on the long end of the winning. Well, let me just ask you, do you, you know, again, I'm sort of trying to cram this into the realm of my experience. The vast majority of the people we charge plead guilty. Vast majority.
I'm sorry?
The vast majority of the people we charge in the criminal system, at least in Bucks County, plead guilty. Their lawyer, who'd be sort of cognate to your position, say, hey, they got you. You know, we waste time with the jury, but jury's going to hang it. Let's cut a deal. Do you send many people away? Or I'm just wondering if these things drag on a long time, you have, and then there's a burden on the Commonwealth or the department, you've got kind of a built-in advantage.
I'm sorry, I'm not sure I understood the question.
Do you send many cases, or do you look at many cases and say, no, you know, sorry, we'd like to help you, but this is a waste of time?
We're very limited by resources, as everybody here is. So we only take cases that are directly affecting someone's employment. So we send away anyone or try to refer. And other than that, we will take any case that we believe should not be on the child abuse registry. We do not send anybody away who we look at a case and think, this is not a case that should have been put on the child abuse registry and is affecting someone's employment.
They need to be residents of Philadelphia
Yes,
County.
and they need to be below a certain income threshold.
Well, thank you. You have certainly given us food for thought.